Welcome to our channel, Card Ventures NG Law, Obata Chambers. I am your usual host, John Choka Obata, attorney, and with me is my senior partner, Paul Machuku Obata. We are planning and environmental lawyers and property consultants. In this episode, we shall be dwelling on environmental litigation, application of common law doctrines. Make sure you subscribe to our channel, like our videos, share them, hit the notification button so you do not miss any planning and environmental law related videos from us. Also, use the comment section.
On environmental litigation. Environmental litigation arises out of allegations of some threatened damage to the environment or to proprietary interests, and the relief sought is a judicial decree or order limiting or forbidding the allegedly threatening activity. Law prescribes litigation to protect and preserve the environment from decadence and makes it possible by its policing role on violators and by the provision of the municipal jurisprudence coupled with precautions. You see, pollution may be inevitable, but what is objectionable and intolerable is that it does not exceed certain limits laid down by regulation. Aggrieved parties, therefore, resort to litigation by commencing a criminal or civil action in terms of environmental values. And so the role of the judiciary here in this regard is to weigh, balance, and dispense justice independently and promptly. So, environmental law cases are divided into two: the civil cases and the criminal cases. The civil cases are by private individuals and group of persons to recover damages, that is monetary compensation for breach of legal rights of the claimant or plaintiff, as the case may be. So we can see that actually environmental litigation involves both civil and criminal cases undertaken in prosecution and defense. You see, so the environmental deterioration cannot be arrested solely through litigation. Please note this. Deterioration of the environment cannot be arrested solely through litigation. You will have to exhaust every administrative procedure. And there is a reason for that. There is a provision for alternative dispute resolution, and that is for out-of-court settlement. And so it is advised that you try the out-of-court settlement. But then when that fails, you can now resort to litigation. But it should be understood here that following the out-of-court settlement, the court should be the last resort. And that is when all the alternative dispute resolution fails. So you can see that the alternative dispute resolution is ultimately cheaper than litigation. It is ultimately cheaper than litigation. Litigation may last longer, may take longer time to conclude than the alternative dispute resolution. You see, and then it also preserves privacy, unlike litigation. It preserves privacy. So, but litigation, you know, is on the records. So it is less formal and less rigid than litigation. ADR is less formal and less rigid than litigation. Parties can choose venue convenient for them. And so parties can also maintain a relationship after resolution of the disputes, unlike the adversarial nature of litigation. But where ADR fails, litigation can emerge. So, this is for the civil cases. You see, when the operators conduct their activities recklessly and unreasonably as to inflict injury or harm on a proprietary interest, like farmlands, persons, water courses, even in the fouling of water. Fouling of water has been in the Nigerian legislation for a very long time as an offense. Fouling of water has been an environmental offense focusing on sanitation and public health rather than ecological conservation. And you know that the Criminal Code Act of 1916, from sections 246 to 248, and the Public Health Act of 1958 dealt with contamination of water. So it's not a new thing. I mean, it's not a new provision. It's been there even before independence. So in civil cases, those affected can take an action in nuisance, negligence, in the rule in Ryland versus Fletcher, or even in trespass to land. So these actions are recognized in common law and now forms part of law of tort. You see, law of tort are common law rights and actions. Private nuisance is a civil wrong, and the plaintiff must have a proprietary interest for recovery of damages, and you must have suffered an injury or harm. You see, in private nuisance, it is the unreasonable interference with a person's use or enjoyment of land or of any right of or interest in the said land. For example, you see, the plaintiff subjected you to an unreasonable noise or smell, that is odor, emanating from the defendant's land, causing physical injury to plaintiff or physical injury to plaintiff's property, that is by way of vibration, causing structural damages or structural defects to buildings, or the plaintiff's pet being killed by fumes, obnoxious fumes. You can take an action on a private nuisance in this scenario. And then you also have the option of going by public nuisance. There is provision for public nuisance. And public nuisance is an unreasonable interference with a right common to the general public, such as a condition dangerous to health, offensive to community moral standards, or unlawfully obstructing the public in the free use of public property. You see, such may lead to a civil injunction or criminal prosecution. You see, thoughts of allowing one's tree to overhang the land of a neighbor or obstructing of the road, the public way, or obstruction of the highway. The actions in these can be on public nuisance. Here, the burden of proof lies on the plaintiff to prove his case on preponderance of evidence and beyond reasonable doubt. Criminal cases in this regard is when environmental law is violated, and Nigerian courts employ the common law principles or the common law doctrines in dealing with environmental claims, and also in public nuisance. You see, public nuisance is a crime. It is a criminal offense. Also in Sawa versus Amakri, 1993. And the court decision in this regard was that there is an unrestricted access to the court for determination of your civic rights and obligations, even without or with the consent of the Attorney General in public nuisance. You know, as then it was the 1979 Constitution. And in environmental litigation, you see that negligence, in order to succeed, must prove the following principles. One, the polluter owed him a duty of care, and the polluter is in a breach of that duty of care, and then that breach has caused foreseeable damage to the plaintiff, where the plaintiff is able to prove this successfully. He succeeds, yes, indeed, in his case.